457th District Court. It's Wednesday, December 4th. I'm John Wirtz. With me is David Smith, Dale Fessenden, Larry Rogers, Bob Bagley, James Byers, Pat Tibbs, and Dennis Tibbs. So as we discussed, Eric, thanks again for coming in tonight. And why don't we get started off with your opening up to 5 minutes, and then we'll do the Q&A session after that for about 45 minutes.
Okay. Well, thank you, John, and thank you, everyone, for letting me interview with you. My name is Eric Yollick, and I am running for the 457th District Court in the March 3rd Republican primary, and I asked everyone for their vote. I asked you for your vote. And the reason that I'm running really is three things. First of all, we have a serious backlog of civil cases, which are basically lawsuits in Montgomery County. We currently have just at about 3,000 pending civil cases. We have one full-time civil district court, which is the 284th District Court. We have one court that about a third of the docket of that court is civil. And then we have a county civil court of law, which has limited jurisdiction, but does hear some civil cases as well. The backlog is costing the taxpayers of this county a lot of money. It's costing the litigants who are involved in those cases a whole lot of money, probably a lot more than even the taxpayers. And it's really creating a problem for the people of Montgomery County. So the legislature in the 86th legislature created the 457th District Court. The Board of District Judges voted in July of this year to make that into a civil court only to address the backlog. There are some fairly large cases that are pending that will likely go into that court. One case in particular that I'm aware of that will probably be heard by that court among its docket. So the reason that I want to run for this court is I'm a 30-year experienced civil attorney. That's what I've basically done my entire adult career. I actually have more civil litigation experience and actually more legal experience than my current three opponents combined. I am the only person who is running in this race who is a board-certified attorney, and I've been board-certified in the area of commercial law and consumer law since 1995. And I think I'm the only person who actually has ever tried a civil jury trial, and I've tried over 200 civil jury trials in my career. I think maybe one of them was as a second chair, and the rest were as the first chair major lead attorney. And I've probably done over 1,000 bench trials where there's not a jury, but you try the case to the court. So we need a very experienced civil attorney in a court like this. You can't put someone who is a newbie into a civil district court. Civil law is by far the most complex of civil, family, and criminal, and it has the most sort of diversity of issues in it. And that's one of the reasons that, quite frankly, Kristen Bays is such a great civil district judge, because she was a 25-year lawyer before she became a judge, and she was an outstanding attorney and really had dealt with a lot of very complex cases. In my law practice, it's mostly been business and real estate litigation, I'd say, in the last 10 years, but I've been involved in banking issues, in a lot of complex bankruptcy litigation all over the country, involved in a lot of environmental litigation, even done some Indian law, which actually is kind of one of the most fun areas of law of all of them within civil law. And so, I do definitely bring experience to the table, and that's one of the reasons, if you look at my steering committee and the people who've endorsed me, which y'all asked about in your questionnaire, there are a lot of attorneys. John Causey, Ray Burgess, David Ward, Randy Bays. There are a lot of people who are very experienced civil attorneys who really supported me, and Randy is one of the people who asked me to run it. So.
Okay, all right, good deal, thanks for that. And again, thanks for coming in. You had mentioned your credentials and experience, and the key differences between you and your opponents in this race and why your experience position is better. And you mentioned 30-year civil litigation, and your opponents don't have that much combined. You said you're the only attorney in this race who is board certified by the Texas Board of Legal Specialization. Why does that matter in this race?
Well, in order to become a board certified attorney, you have to have tried a certain number of jury trials and also bench trials. You have to have really reached a level of proficiency which is not common to most attorneys. You have to take an exam in that particular field. And so it does show that you've reached a real level of expertise in an area of law. And so it does make a difference.
Okay, and then also that you're board certified in consumer and commercial law, because business litigation is part of your law practice. Are you aware of your opponents having the same or not?
Same as in what?
Being board certified.
I'm pretty sure that none of them are board certified. Now, I don't know, one of them may be board certified in criminal law, I don't think so though.
Okay, all right, thanks. Dave?
You know, every time we have a judge come up, they always want to talk about court efficiency. And I spend my life in manufacturing. I can walk into an industrial company and I say, oh, I can, you know, I know what to measure to get results. So what do we measure? What do we measure to know that in the future, you know, a judge is doing a good job? Because it seems like a black hole. You know, how do we put statistics together?
I'm not sure that a black hole really is the way to describe it, David. I think that there is a real problem, and I'm not really mentioning any specific courts in Montgomery County, but there's a problem, especially with civil district courts, that it seems sort of like a country club. They don't work long hours, the courtrooms are dark. So I think one measure that you can have is certainly how much is the judge on the bench, moving cases along, how many jury trials are they trying in a year. There is certainly probably the easiest measure is what is their disposition of cases in comparison to the number of cases that are being filed in the court. And so the disposition ought to be significantly higher than the number of cases that are filed. And, you know, obviously, in a situation like what we have in Montgomery County right now, that's not the most fair judge because we're short of courts. And so, you know, all of the cases are going into the 284th District Court. I think Judge Bays actually is disposing of more cases than are being filed, but it's a small differential. And the reason it's small is just simply because, and she's really working very, very hard and long hours. But the problem is that, you know, we just have a shortage of courts. And we do need this additional civil district court. So I think that's another measure. You could say that the percentage of reversal rate is a measure, but the problem is so few cases are really even appealed that that's really not a very accurate measure of how good a judge is doing. But I do think that just, you know, walk around the courthouse on a Friday afternoon. Is the court operating? Is the judge on the bench? My intention is that if I'm elected, I'm not going to have an office. I'm going to use the courtroom as an office. And so you'll be able to tell how long I'm working. If I'm not sitting on the bench, then I'm not working.
Okay, currently you are a lawyer. Please describe your law firm and what will become of that law firm if you're elected.
Well, I mean, right now my law firm is me. I'm a solo practitioner. It's the same firm that I've had since 2000 maybe. It's had up to 4 lawyers in it. And I think that's right, I may have had actually 5 lawyers at one point. I'm a solo practitioner right now. I have one gentleman who is a paralegal who works for me, and then one lady who is is my longtime legal assistant, who has worked for me for a long, long time, more than 2 decades. I work in that law office about 80 hours a week, and it's mostly business litigation, a lot of real estate litigation. For some reason, easement lawsuits are just abounding in Montgomery County right now, just because of the growth probably. And under the Judicial Conduct Code, if I'm elected as a judge, then I have to close my law practice. You can't practice law as a judge.
Okay. Okay, Larry?
And a question, Aaron, in the opening, you give us a pretty good history of going to school and all of that. And you said you're licensed in Colorado in the District of Columbia, as
Right.
well as many other federal courts. Why would an attorney do that?
I really haven't practiced much in DC. I think I've had maybe 2 or 3 cases in my whole career there. I've had a substantial law practice in Colorado though. And at one point I would say about 1/4 of my law practice was in Colorado. I used to try a lot of jury trials in the western slopes area of Colorado, and really enjoy practicing there. I mean, not just because it's fun to go to Colorado, but the courts are really good there, and I got to know a lot of the judges and felt very comfortable there. The reason that you get licensed in the federal courts is because oftentimes, disputes have to be heard in federal courts. And so in Texas, we have 4 federal district courts. I'm licensed in all 4 of them. You have to be separately licensed in like the appellate courts.
Gotcha.
I mean, that's what it is.
Okay. You went to Princeton University.
Yes, sir.
And what's very interesting is that you didn't go there to study law. You studied economic geology for the senior thesis is what you got a prize for. And you studied mineralogy. How did you get sideswiped into being an attorney?
It's the other way around. I really decided when I was about 10 years old that I wanted to be an attorney. And the reason that I ended up majoring in essentially what's called economic geology, hard rock mining geology at Princeton, is because I just wanted to do something a little bit different. I really enjoyed math and science. I took a lot of mathematics courses in college, and just, I've always felt that it doesn't really matter what you major in college as long as you do well in college. And I did do well in college, and by doing something that I enjoyed, it helped me do well.
Sure. Okay.
You've contributed over the years to a number of organizations. And now that you're a candidate, do you think it's gonna look like a pay-to-play when some of the organizations and people start endorsing you or supporting you?
Well, first of all, I don't know that anyone's endorsed me yet, Bob, but
I'm just asking. When they
do I
do.
think that it looks like pay to play? No. And I'll tell you why. I mean, I obviously have been very active in a lot of political issues. And so over the years, I've given money to organizations that I felt would help me in moving some of those issues forward. For example, I have contributed to this organization. I've contributed to the Patriots PAC. I assure you that when we had issues where I was concerned about the position of the Patriots PAC, for example, in the Conroe ISD bond issue, I didn't go to them and say, well, look, I gave you all this money, but it certainly opened channels up that I had a history of contributing to them, and it definitely did help. Same thing. I gave one large contribution at one point to the National Republican Congressional Campaign Committee, the NRCCC. That opened up a major door for me to help me on some issues that I was very interested in. It had nothing to do, because honestly, I really have never had any particular ambition to run for, certainly not this position, because it didn't even exist until a few months ago. I really, didn't know if I was going to be running for office ever again. It's always been issues that have been my motivation in giving money to every organization on that list.
James?
I'll ask later about case management, load management. I want to do something a little interesting first. Now, we know that there is a move in different courts to use Sharia law, certainly a move among Sharia adherents to get Sharia law in our court system. A lot of people don't know that we've already had quite a long history of religious covenants enforced in our courts. The only ones I know of were Catholic covenants, and usually dealt with child custody, where both parents agreed when they got married in the Catholic Church, they raise their child Catholic, one leaves the church, and respecting that, the court gives custody to the remaining Catholic parent. Along that line, Sharia law covers a lot when it comes to financing and banking. So let's just say that a case comes, civil case comes before the court, where you have the parties to the particular financial arrangement, they covenant to abide by Sharia provisions. How would you as judge handle the situation where one party decides they don't want to do that anymore, so they're in violation of that covenant to abide by Sharia? To give you an example, Sharia law prohibits interest. And let's say one person decides they're going to renege. So as judge, you find yourself in the position of, one, having to understand Sharia law or not, you tell me. The other is, if understanding it, having to enforce it or not. How would you handle the use of religious law in a civil case?
Okay, well, so let me take your precise example that you gave with the contract.
Expound, sure.
Where they say they're going to be applying Sharia law. If they're going to have specific provisions that are actually in the contract, where they say, for example, there will be no interest, then I'll enforce that, okay?
Well, usually it will be, just like you have credit card agreements that say, laws of the state of South Dakota will apply. And in this case, it would be the provisions of Sharia law regarding finances will apply. Even with inheritance, where the woman gets half of what the man. So how would you answer that?
It ain't going to happen.
And you would tell them that would be, the basis of that would be what?
The basis of that is that in the United States and in Texas, which is included in the United States, we operate under the Supremacy Clause of the United States Constitution.
Okay.
The Supremacy Clause basically, and all of the case law under it, says that a state is to apply its own law and to use its own laws with respect to conflicts of law. In other words, to decide which laws are applicable to the case, okay? But you don't choose from some religious law. Your choice is very limited. Your choice is basically limited to one of the 50 states or the law of the United States of America, which is a separate body of law from the 50 states. Now, there can certainly be situations where you have to apply, for example, Mexican law to a transaction, okay? If the parties agree that
In state court.
In state court?
Oh, yeah.
In fact, I've tried a case where we had to figure out what Mexican law was with respect to a tax issue.
So that's not an issue of improper forum?
There could be an issue of improper forum because, the problem is that there's a lot of sort of procedural issues with an American judge, for example, who doesn't speak Spanish, in trying to apply that law. And so actually the one case that I'm talking about, there was a motion to transfer venue, the judge denied it, and then he went forward and heard testimony on what Mexican tax law was, and quite frankly, he completely messed it up, and so both sides ended up appealing, and we won the appeal. And so, there are real problems with that, but I can tell you right now that, I'm not gonna tell you how I'd rule in a particular
Sure.
case, but Sharia law is not applicable in the United States of America or in Texas.
So would any
Period.
arrangement like that be null and void?
No, if they have a contract, and
Uh-huh.
their contract has provisions in it, but if what they're expecting is for an American court to start applying Sharia law, that's just not gonna happen.
What about
It shouldn't
deferral
happen.
to a Sharia court?
Well, if they wanna do that, if both sides
Well, no,
decide.
one side doesn't, but the other side says, hey, the other side agreed to this.
If the court has jurisdiction, if the
Right.
American court has
Yeah,
jurisdiction,
that's a,
and
we'll
if
say
it's
that's a
proper
good
venue, then it's the place to litigate the case.
one. Right, thank you.
Sure.
Okay,
That's an easy one.
you, like many of us, are outspoken, unrestrained political activist. So as a judge, are you gonna be able to switch that off? And will that be the basis for people to appeal your rulings or ask for your recusal?
Okay, so you've asked really two questions, all right? And I want to say this, Dennis, there is a real confusion about the word activist. Yeah, I've been a political activist. That means that I've been very active politically. I've worked on issues, I've worked on campaigns, I've worked for the Republican Party since 1976, okay? And I've, sometimes I didn't work as hard as others, but basically I've been really active, okay? That's a political activist. That's not what an activist judge is. That's a very different definition. An activist judge is, in my mind, a judge who legislates from the bench, who basically creates law from the bench. And no, I will not be an activist judge. Never, and I want to be clear about this.
That really wasn't the question.
I know, but I'm going to answer the whole question. But I want to be clear about this, that in all of my political activism, I have never argued that people should ignore the law. Really to the contrary. Now, to answer your question specifically, that's more like about recusal. I cannot imagine what situation I have been in, with one exception perhaps, where I would need to recuse myself from a case, okay? And let me give you the extreme example where I would not have to recuse myself. There is a gentleman who I have been very critical of when I was the publisher of the Golden Hammer, and he doesn't like me at all, and I have absolutely no opinion one way or the other about him. I'd shake his hand, and I would save him from an onrushing car in a heartbeat, but he doesn't like me at all, okay? And he happens to be one of our 5 commissioners. Now, I don't feel that I would need to recuse myself because Commissioner Riley would get a fair playing field in my courtroom, okay? The one situation where I think that I would need to recuse myself, in all candor, I have a pending lawsuit against the San Jacinto River Authority, where it's Eric Yollick individually versus the SJRA. I think that it would be completely inappropriate for me to hear an SJRA case. I don't have anything against them. I don't like what they did with respect to one thing, and that's why I sued them, and I actually won the lawsuit, and they've now appealed it to the Beaumont Court of Appeals. But, in that instance, I would probably recuse myself in SJRA cases. Other than that, I can't even imagine the scenario. There is no one that I dislike, and I'm really serious about that. I don't dislike anyone in this county, not even Charlie Riley.
I guess I was thinking about the cases where a well-known Democrat might be on the losing end, and he could cite the fact that you opposed Democrats and openly supported Republicans.
That is not grounds for recusal.
Okay.
There's been a lot of cases on that in Texas jurisprudence, and, I would give Jay Stillberg as fair a shake as I would give Mark Keogh if they were in a lawsuit against each other.
Well, do you think you'll still be able to do the sorts of things that you do now, once you become a judge?
I think that the moment that I filed my notice of appointment of treasurer, it became inappropriate for me to make a lot of the citizen comments that I made. It would be inappropriate for me to endorse any specific candidate. And there may be some other things that are inappropriate. But I mean, look, I know how to compartmentalize. When I've acted as an attorney, I have not been a conservative political activist in the courtroom. I've been an attorney, okay? And I've done that for 30 years pretty successfully. And so I understand that people don't want to see a judge who is a political activist on the bench, and that is certainly not appropriate.
Okay.
Just quickly on that, I mean, I know a number of the judges here, and when I've been in their court, we never really talk about it. They don't cut me any slack. I would assume if I'm in your court, you're gonna cut me any slack?
Nope.
That's what I expect.
But at the same time, James, you're also gonna have a fair playing field. I'm
Of
not gonna
course,
treat
yeah.
you discourteously. I'm gonna treat you with as much kindness as any human being deserves.
Good.
And one of the questions, please describe what you believe are the most significant issues in the race, and why not, what you'll do to address them. You said there were three. One is efficiency of the court's docket, and I thought it was really interesting what you would do to speed up the efficiency on that court to process these backlog of cases through, to try to clear all that
Right.
up. The second one is reform. You said as a member of the board of district judges overseeing the work of the Montgomery County Auditor, you will fight for careful oversight of the county finances to reduce the taxation and spending burden on the citizens. Explain to the audience and on the camera here how that would work.
Okay, well, first of all, I want to be clear that that would probably be about 0.5% of my time acting as a district judge. But, you know, about 2 years ago, I became involved in an issue with respect to trying to get the Board of District Judges, which has the formal oversight power of county finances, to actually begin taking their responsibility seriously. And it was really Bill O'Sullivan and I who started lobbying them pretty vociferously to get them to do their job.
What do they do now in regard?
Well, they're doing a lot more now, and so it actually worked. And really, we had a big victory at the end of 2018 when they finally stepped in, terminated the county auditor, Phyllis Martin, and replaced her with a gentleman who is just doing a superb job as the internal auditor for the county. Under the Texas Local Government Code, the Board of District Judges has the responsibility essentially to oversee county finances.
So oversight.
Oversight. It's not, they don't make decisions, but they have every right to basically oversee the auditor, who has every right to audit the entire county government, not only the money part, but also the legal compliance part. That's what internal auditors are supposed to do. And so, Bill and I went in front of the Montgomery County grand jury. We asked them to issue an order to do a formal audit under, I think it's chapter 115, section 0.053 of the local government, I think that's the section, I may be wrong, of the local government code. We got the grand jury to do that. A judge issued the order for it. She appointed 3 auditors, and they just ran into a brick wall. And the audit that was supposed to have been done was never really even begun. So I would like to see, that process move forward. I think Rakesh Pandey is doing a superb job as the county auditor, but, as a district judge, I would be in a position where I could offer him some suggestions and offer the Board of District Judges some suggestions. I mean, as you all know, county spending has been my issue. That's been my core issue
Ours
of what
too.
I've been doing.
Yeah, that'd be great.
Okay, thanks. Steve?
When you almost do anything today in terms of buying a service, buying a product, there's always terms and conditions that you click on nebulously, but embedded in those things are mandatory arbitration clauses. And basically, we give up our right to go to court, basically, these mandatory arbitration clauses. Do you think there's too much of that we should take more things before the court versus giving up our right with almost no choice? You take If your kid takes an SAT test, he takes that test, he gives him the right to go to court if there's a dispute with the SAT, College Board.
It depends, honestly. I have to admit that my opinion about arbitration has changed quite a bit. If the arbitration provision says that we're gonna go arbitrate and it's a dispute over rice, and we're gonna arbitrate the dispute in front of the Rice Millers Association, which you laugh, but I actually have been involved in a case where that exact dispute occurred. Yeah, I have a real problem with arbitration, okay? It's what's called a contract of adhesion, where basically the party that drafts the contract sticks in this, sort of little tiny provision that no one ever reads, and then they've all of a sudden given their right to go to court, and they have to go in front of this general tribunal. I will say this though, David, that I've arbitrated a lot of cases where I'm an attorney for a litigant with the American Arbitration Association. I've never had a case with them where I felt that it was an unfair arbitration. I've actually arbitrated some cases myself where I was the arbitrator and never had an appeal of any of those cases. It depends. I do have a real problem with consumer contracts that have arbitration provisions in them.
Yes.
But let me be clear about this. When I say I have a problem with that, that's Eric Yollick talking. If I'm the district judge of the 457th District Court, I have to follow the law, and the law in Texas is very clear with respect to the provisions. It's Chapter 171 of the Texas Civil Practice and Remedies Code, and courts don't have a lot of choice whether or not to enforce arbitration provisions. Now, there's some exceptions. There's unconscionability. If you have an arbitrator who's acting through fraud, then you certainly can, get around at least that particular arbitrator. That deal with the Rice Millers Association that I mentioned, that's fraudulent.
What about, in the same vein, employer do not compete? We used to be that the senior executives that do not compete. I'm aware of companies now that any white collar employee comes in and signs a do not compete. And it seems like, some states don't recognize it at all, other states do. So what are your thoughts on that?
Unfortunately, David, that's once again statutory law, and so, it's not gonna be my position as a district judge to set aside the statute. Covenants not to compete are enforceable as long as there are certain safeguards. It has to be a reasonable geographic area. It has to be a reasonable market. There are certain other safeguards of that nature, reasonable amount of time, for example. But, I'll say this, I've been on the other end of covenants not to compete too, where, I've served on the board of some companies, for example, where, we have to hire someone with a covenant not to compete because, the first thing we do, the first day they come on the job is we're gonna give them a bunch of trade secrets that are genuine, like design secrets on, how you build our specific type of blowout preventer. We're not gonna share that with someone unless they have a covenant not to compete.
Bill?
Okay, one of the questions is there anything in your background of an embarrassing nature? You said no. And your final comments on that question were, there are many urban myths about me, thanks to the political establishment, which hates me, and thanks to the Courier blog, which has written some fiction about me. Well, the Courier blog indicates that there was a jury trial, that fraud was found to be, conviction of fraud, 12-0 on the jury trial.
No conviction. I was never convicted. You don't convict people in civil court.
Right.
Okay,
That's Charlie Riley's term,
okay.
okay?
But there was a jury trial, it was 12-0, right?
It was
Okay, and a $118 million judgment.
against the bank, not against me.
Right. But you were the hub of the wheel.
No, that's not what the jury found.
Okay.
See, that's once again, I mean, that's part of the urban myth. And first of all, I want to be real clear. Of anyone who is asking that question on this committee, I appreciate very much, Dale, that you were the person asking it, okay? And I'm happy to explain why, but I'm going to answer your question first. So what happened in the J.J. Walker case was, I was the attorney for First National Bank. There was a jury trial where the bank was sued. They sued another healthcare company as well, and they also sued me individually. The jury found that of this transaction, which was a very complex transaction, a loan transaction, they found that I was 10% at fault. But the judge, Sylvia Matthews, who was the trial judge and sat through the full 3-week trial, she determined that there was absolutely no evidence of fraud by me whatsoever, and she threw the verdict out as to me entirely. The plaintiffs then appealed the case, and they went to the Houston Court of Appeals, and the problem that the plaintiffs had in that case was that there was no evidence that I had committed any fraud at all. And so what the Court of Appeals had to do was they had to create new law, and so they did. And so for the first time in Texas, someone was found liable for the actions not of their agent. So this isn't like a car dealership responsible for their agent, you know, the car salesman. It's the other way around, where all of a sudden the car salesman is responsible for what the car dealership did. And so the Court of Appeals said for the first time in the history of Texas that an agent, who was me, was liable for what the bank did. And so they created new law in that opinion, and they then said, okay, under this new law that we've just created, we're going to send this case back to the trial court. And so the case went back to the trial court. There was never a judgment against me, and while I was in the trial court awaiting to go to trial, I settled with the plaintiffs. That's what happened. I wasn't convicted of anything, and I'm not blaming you, Dale, for that. I mean, that's a phrase that Charlie Riley, Kristen Nicole, all of their little group of about 40 people in the Magnolia area that they've been propagating on social media. That's certainly a phrase that the Courier blog tried to get out there as well, because they weren't happy that I started the Golden Hammer, and so a few days after that is when they came out with that article. And so basically, you know, there are urban myths about that, and you know, I can tell you as an absolute matter of fact, my credit is almost perfect. I think my credit score is like in the 840 range. I think a perfect credit score is 845 or something like that.
Do you co-sign?
No, but I mean, you know, I've never had a judgment against me. My wife and I have paid our bills by return mail since we were in our 20s. Vendors love doing business with me because of that. You know, I use court reporters. They adore me because they get paid so fast. I mean, I just don't do business the way that the Courier and Charlie Riley have tried to depict it. It's ridiculous.
Okay.
So
Okay.
can I follow on to that real quick? You mentioned the Courier blog several times
Yeah.
there, and the person responsible, I think, for that article was Catherine Dominguez.
That's correct.
Wasn't she on the board of the hospital district, or if not on the board, and serving in some capacity, and then you were serving on the board, and there was, I think, an action to get her removed, and she was removed or resigned? or
Actually, it's
whatever.
even worse than what you're describing.
Oh,
okay?
really? Okay.
Yeah,
And do you
Catherine-
think there's vendetta on
Oh,
her part
I
against you?
have no doubt that there
Okay.
was. Catherine was the director of the Community Relations Department for the Montgomery County Hospital District. I was actually appointed to the board in March of 2003. My first board meeting was April 15th, 2003. At that meeting, I made a resolution, I came forward with a resolution to cut $5 million out of the, I think it was $27 million budget, I think, at the time, of the hospital district. I may have those numbers wrong, but I mean, it was about a 20% budget cut. the first department that had to be cut in order to save that money was the Community Relations Department. And so on April the 16th, 2003, the day after we did that, Catherine Dominguez was fired from the hospital district because she had been hired by Nicole Huff, who was, the real liberal on the board, and Nicole was her buddy. And so, yeah, there's no question that it was payback for that. It was also payback because Catherine and her boss knew that I was about to start the Golden Hammer just a few days after that article came out. And so, yeah, I mean, it was terrible. And there's even a worse aspect to that story than what we're talking about.
Sure.
Okay. On our questionnaire, we asked, please describe what you believe are the most significant issues in this race and why and what you would do to address them. And you've kind of covered number 1 and number 2, your answers. The efficiency of court dockets, you've already covered that. Number 2, reform. Past 3 years, I have devoted enormous time. We've gone over that. The third answer was unifying the Republican Party. My question is, what does your answer number 3, unifying the Republican Party, have to do with the most significant issues in this race?
Okay. Well, so it really doesn't relate to me being a district judge. It relates more to me running for district judge. I am very committed to Montgomery County doing what this nation needs for us to do in the November 2020 election. And that is, in 2018, as a county, we delivered 42% of Ted Cruz's winning statewide margin. I heard Kevin Brady actually at y'all's meeting saying that the 8th Congressional District delivered 55% of his margin. Now, I don't know if that number is right or not, but the 42% number I know is correct. And so there is no question that if Montgomery County does not deliver a huge margin to the Republicans who are running, President Trump, whoever is the U.S. Senate candidate, and it's probably going to be Cornyn, but I mean, whoever it is, the rest of the Republican ticket, if we don't do what we did in 2018, and really even better, then we could potentially lose Texas, and if we lose Texas, then one of the crazy Democrats is going to end up being the President of the United States instead of Donald Trump, who's doing a great job, okay? And so one of the reasons that I want to run for district judge is I want to be the Republican nominee. I've made a commitment to James Dickey personally. I spoke with Greg Abbott about this about 4 weeks ago in Austin face-to-face, and he asked me about it specifically. And I've made a commitment that I will spend a fortune on my race in the general election, because there will be a Democrat in my race, and I will do everything I can to help the rest of the Republican slate so that we get a huge margin of victory in the general election in November. I mean, it's critical. If we don't do that, we're going to lose the White House. That's what I'm talking about there.
We talked earlier about cases brought up in court, and I don't really know that the public knows exactly what kind of cases come to your court. Can you explain
Yeah, sure.
some of that?
So in Texas, district courts are sort of the main court to hear civil cases. And what civil cases are is they're lawsuits. So they're not divorces, those are family law cases. They're not criminal cases, so no one goes to prison or gets fined in a civil case. It's where one party is in a private dispute with another party and is asking the court basically to come in and be the referee.
Probate?
Now, I'm sorry?
Probate law?
No, probate is in the county court. In this county, some counties have actually statutory probate courts as well. So there is no probate jurisdiction in district courts.
Go ahead, sorry.
Okay. District courts have a minimum jurisdictional amount of $500 and their maximum jurisdictional amount is infinity. So if you have a case that is over the jurisdictional limit of the county courts, then it has to be heard in a district court if it's a civil dispute, okay? And so that's what a civil district court would hear, is it would only hear civil disputes.
So real estate,
Oh, yeah.
issues.
Real estate, breach of contract, personal injury cases, car accident cases. I mean, really anything that is a civil dispute is what a civil court's gonna hear.
So would it be a civil issue if you were a parent, not wanting your child to be vaccinated or taken care of, through the medical world, and would you hear that?
Or the family is sued by the hospital or
yeah.
a doctor.
Right.
I think,
Or
that-
there's a debate between the two.
I think those cases probably would be in a civil court. If the cases are brought under the family code though, if there's a family code provision, then it would go to the family courts. And in this county, I think it's 3 of the, maybe it's 2 of the county courts of law, and then the 410th and the 418th, your family cases as well.
Now, we get into procedure on the civil cases. I haven't found any 2 judges in Montgomery County do exactly the same, but my question is more towards caseload management. Normally, you would, not necessarily, you would have pretrial hearing, then the actual hearing, and before the pretrial hearing, a day you call in to know about the pretrial hearing. Let's say one party doesn't do the call-in, or you're going to dismiss the case. That helps with the load. They call in, but they don't show up for the pretrial hearing. You never hear from the other parties to why. Would that be a dismissal? They don't show up for the final hearing, and they don't call to say conflict or whatever. Is that a dismissal? Would that be a technique you would use? Or what about forced arbitration or forced mediation, basically delegating the court's jurisdiction to a mediator or an arbitrator? What would be your method for caseload management? Would you prioritize? How do you want to do your caseload?
Okay, well, so let me answer your specific questions
Okay.
first. The only court that I'm aware of that has that call-in procedure in Montgomery County is County Court of Law Number 2.
Yes,
Judge Laird, okay? And, I don't really have one particularly strong feeling or another. I've had a lot of cases where I represent a defendant where the plaintiff never calls in, so she dismisses the case. That's kind of cool. But to be honest,
For your court?
I'm not going to do that. I don't think it's necessary. I think what you do is you just set cases for trial. You set up scheduling orders well in advance, and then as the case gets to trial, basically the trial docket is going to be set about 2 weeks before the 2-week period when cases can be heard. So in other words, if it's set on December 15th for a 2-week trial period, then on December the 1st, parties would be able to go to the internet, look up and see where they are on the docket, okay? So there's not gonna be a call-in procedure. They're not gonna have to go to a pretrial conference. That is a huge waste of time.
Yeah.
And let me tell you, I gotta tell you something. There's a judge, and he's no longer on the bench, the 269th District Court in Harris County. He would do these pretrial dockets where there would be 400 attorneys in the courtroom every week. And it seemed like all he ever did was have pretrial dockets because he was so busy. I mean, it would be all day long that he would do these crazy pretrial dockets. That is a total waste of time for the court, and it's a total waste of money for all those litigants who are paying attorneys, $250 an hour to sit there in a courtroom just twiddling their thumbs. So
how will you speed it up?
the way you speed it up is you do everything electronically. You set your docket electronically,
Yeah.
you set scheduling orders electronically, you don't have docket calls. We do have some courts where you have docket calls, and they're just enormous waste of time.
Can you do a ruling without requiring a face-to-face hearing?
Absolutely, you do it by written submission, and so as many of the, in fact, I think I said that in my questionnaire, as many of the pretrial motions as you can set for written submission is exactly how I will do it. Some pretrial hearings, like a temporary injunction hearing, that requires evidence, okay?
Right.
So you have to allow.
Evidence,
people
you'd have to have the hearing,
Yeah,
correct?
of course you do. But I mean, motions for summary judgment,
Yeah.
motions to dismiss, discovery motions, like motions to compel or for protective order, from discovery requests. That should all be heard on written submission. It is so rare nowadays for a motion like that to need to be heard orally. You just don't need it. It's a waste of everybody's money and time. And that's how you move cases.
Of course, it means you have to look at the paperwork before the hearing. I mean,
Well, no, it
Most
means that the
judges
judge
don't.
actually, right, it means the judge actually has to read the motions, and it
Yes.
means the lawyers have to write good motions.
Yes.
Because let me tell you something, one thing that I always used to see, especially in the 90s, is the lawyers would write these like 2-sentence motions, and then they'd show up and they'd try and argue
They
because
still
they
do.
had oral hearings.
Yeah.
And that's garbage. What they need to do is they need to make their full argument in writing. The other side then gets to file their response. If they want to file a reply, that's fine. And then the judge considers it by written submission. And like I said, I'm going to be sitting in the courtroom and making rulings, okay? I'm not going to be sitting in some office and hiding where you're wondering, is Eric really on the golf course? Or is he watching the latest Quentin Tarantino movie? Or is he, actually working? You're gonna know when I'm working because I'm gonna be sitting on the bench in the 457th District Court. And you will see that I'm on that bench long hours into the night.
Last question.
Okay, so your bench is your office, and you're gonna be there long hours. How many people are gonna be employed by that court, and are they gonna have to be staggered by shifts, or is everybody gonna work the
Nope.
same?
Nope.
Or you can work it out?
I can work without them, okay? What I'll need is a laptop. Actually, since I'll be in the courtroom most of the time, I'll just be able to use the desktop, okay? No, what you need staff there for is from essentially 8 to 5 days a week. And what they need to be doing is handling the docket, doing the scheduling. You need to have a court reporter in the courtroom for evidentiary hearings or trials. And I'd only do that during work hours. And let me tell you, one of the reasons, and look, nobody, seems to like lawyers, but lawyers are very hardworking people. And, I've been a lawyer for 30 years. I know how hard it is to practice law. There is a limit to how much you can abuse lawyers and still let them be effective advocates for their clients. If you start holding court in the middle of the night, which I've seen judges do, by the way, nobody gets anything done. It's a waste of time, and like you said, or you suggested, then you've got a court reporter tied up who's got to work there, and all the court personnel and the bailiff has to be there, and they're all getting paid overtime. That is a very inefficient practice.
I've never seen a judge on the phone. Are there phones on the bench?
Sure, in fact, I've seen a lot of judges, and I think most of them here allow people to appear by telephone, not for trials or evidentiary hearings, but, just like a normal motion, you can normally appear by telephone if you had arranged that in advance.
And if you're successful and the county catches up on all its civil backlog, if they were to assign you some sort of criminal portion of your day, would you be able to handle that?
I would be very comfortable with that. I haven't practiced criminal law, Dennis, but I'm very familiar with the Code of Criminal Procedure. I've done a fair amount of work where, for example, there's a civil case and there's a parallel criminal case, and so I've had to work with criminal defense counsel and my client in those situations.
All right, thanks.
All right, we're at that point where time to wrap it up. Take up to 5 minutes if you like on your closing, and then we'll call it a night.
Well, okay. I want to be pretty blunt with you guys about something. I vetted with you 3 years ago, and I enjoyed talking to you about it, and quite honestly, I've really enjoyed tonight as well. But I really was not happy with one particular thing that happened, and so I want to address that in these 5 minutes.
Sure.
And that is that there were some issues that we didn't talk about in the vetting session. Now, maybe y'all didn't even know about them when you vetted me back then. One of them was the case that Dale asked me about, and that's why I appreciated that you did. But, there's a lot of garbage out there that I understand, and I knew when I was going into this race that I would be tested, and that the real test for me is to show that I can act with a judicial temperament in the face of some extreme belligerence from people like, the establishment, who, what I have been doing as an activist is I've been essentially shining a mirror at them, and they've seen some things about themselves that they really don't like very much. Now, I understand that's not my role as a judge, as the 457th District Court. And so I have to show that I have judicial temperament. But at the same time, what I fully expect that I'm going to see in the next 4 months in this election is I'm going to see a lot of, these sort of attempts. And there was one at the County Executive Committee meeting last night that was just complete garbage from what I understand. I really didn't witness it, and my understanding is some of the people in this room may have seen some aspects of it. But I don't really think, and y'all have asked me the question, is there anything in my background that's particularly bad? Look, if I said that I'm some angel and I'm a perfect person, then I'd be lying to you. As far as I know, there was only one perfect person who ever lived on this planet. But I don't think that there is anything that I'm aware of. I'm happily married. My wife does some things that I don't know about, that I've even discovered in the last few days that I don't approve of. But that doesn't make her a bad person. It just means that she does some things that I don't particularly like. And I'm not being critical of her. I'm just saying that has absolutely nothing whatsoever to do with me, and it has nothing to do with how I would perform as the 457th District Judge. There is, this sort of urban myth about me supporting Democrats in the past. And look, I wanted to put these things on the table because y'all did not ask me these questions, and so I want to address them right now.
Sure.
And so, I talked about this when I ran for judge 3 years ago. This exact same issue came up. My wife, who has been a homemaker, does not have the credit to go and get her own credit card. And so she used my credit card when she gave a contribution to a candidate that I would never support. And that's why, during the same time period when I was giving the maximum contribution to Donald Trump, you would see that she was giving the maximum contribution to Hillary Clinton, who is someone that I would never support.
That's her right.
It is her right, absolutely. And, we're happily married. That doesn't mean that we're agreeing on every political issue. And the truth is, y'all would be surprised if you talk to my wife. You'd probably agree with her more because she, on issues like government spending, she's very conservative and very, I would say, almost, free market libertarian. But there are issues like stem cell research where she has strong opinions because of the situation that occurred with our son. That, she's almost a single issue voter on stem cell research. And I'm not. So, I wanted to get that on the table. If there are other issues that y'all know about that I need to address, I'd really like for you to ask me about them now. And that's how I wanted to use my 5 minutes.
Well, you brought it up last night, so I'll
Yeah.
be the one that brings
No,
it up.
please
We had an individual that got up there and was talking about your wife being an author of gay porn, basically.
Well, no, he didn't say author, it was very misleading, and I found it very objectionable, and wanted to, the guy should be censored, we should censor him. He was saying that those were things that the two of you said and did. And I was going, what on earth? And he's got a book. You know, I didn't find out till later, oh, someone wrote a book, and, you know, well, it was a romance novel or something. Who cares? So I didn't follow that at all. It was just, he was pissed at us, and he looks at you as an easy target because you're well known. That's all I saw last night. What he did was
He did-
completely
So
out of bounds.
He
Here's
did
what I-
say, he
here's
did
what
say
I-
that
it was
his wife did
slander,
it.
okay?
He did say that his wife did it. and-
So here's
and wrote
here's
it
what I
up.
know about it. Mr. Reynolds had a copy of some book that I have never seen before, although I did see the cover of it today. There were some photographs that were taken that were provided to me of the inside of that book this morning, and I didn't look at them because I have absolutely no interest whatsoever in looking at gay pornography, okay?
That's what he was saying, yeah.
No, I just, you know, someone said that that's what was in it, I'm not gonna read that.
Right.
I don't wanna read it, that's gross, okay? And so, you know, this gentleman went through and he apparently read the whole book, maybe more than once. He marked with pink sticky notes where,
A lot of them.
yeah, where he found gay porn. On the same vote,
He looked very
he then,
closely.
but let me tell you, yeah, he did.
Yeah.
And, you know, on the same vote then, he is the person who defended someone who is being removed from committees of the
Yeah.
Republican Party because he goes around wearing dresses and claims that he's transgender. And, you know, look, my position on homosexuality is if someone wants to do that stuff in the privacy of their bedroom, they are, as far as I'm concerned, you know, that's between them and God,
That's their business.
okay? And it's none of my business, and it's
Right.
not the government's business. But I don't wanna hear about it. And so what Mr. Reynolds was doing last night was, he was broadcasting the fact that he was reading gay pornography. And,
That's a
you know
very
what?
accurate.
I'm glad I wasn't there for the meeting. You know, I don't know if my wife wrote gay pornography or not, but I'll tell you this, I know a little bit about some of the things she's written. I've never read any of her books. I don't like her books. And I don't like this stuff at all. And I'm not gonna mince words about it, honestly, okay? My position on homosexuality and on even legal issues related to that could not be clearer, and it's been the same position for decades.
How many books has your wife written?
I have no idea.
Like dozens?
I don't know. All I know is this about her books. She's never made a dime on them. A few, I think one or two of them have been commercially successful, and she's given every penny of her royalties and advances to the Knight Cancer Institute, which is part of the Oregon Health Science University, and they are the largest research facility in the world for cancer, for basic cancer research. You know, it's named after I think Roger Knight, you know, who's the founder of Nike. He gave them, I think, $1 billion to start it. And so my wife gives all of her royalties to that. I think that's great that she's giving money to cancer research. I'm all for that. It's it's private research. It's not government money going to research, which I like too. And so, you know, that's fine. What she is writing, and someone actually this morning read to me something that supposedly is in one of those books, and I did find it very disturbing. Sorry.
That's fine.
Great.
Well, as a Republican Party chairman, you know, I apologize for that behavior. It was inappropriate, and, you know, I'm really struggling with whether to file a motion for censure. I just don't know if we're gonna be meeting again before the primary. in which
Yes,
case,
we will, February 2nd.
well, then I probably will file a motion to censure.
You know what, James? I hope you don't. And-
Well,
and
it's not
let me
just
tell you
that,
why.
he's been very disruptive,
Yeah,
every
yeah.
single meeting, no
I know.
respect for the rules of order.
He has, but you know, this is a free country and people should be allowed to express themselves. And, you know, I don't, that aspect of it, I don't really have a problem with. I don't like I don't like when they do these gay pride parades. The problem I have with them is not the gay part, it's
Right,
the
no.
pride part. I don't even like it. One time, my wife and I were on a walk in East Shore in the Woodlands, and there was a man and a woman standing in the middle of the street, and they were making about as vociferously as people
yeah.
can do that. And I didn't like that either.
No.
Okay, I don't like people flaunting their sex, not their sexuality. It's their sex
Right.
in public. That's gross. and it just shouldn't happen. That's the problem
Yeah.
with it.
Totally agree.
Yeah.
Thank you very much, sir.
Thanks. Thank you all
Appreciate
very
coming
much.
in.